How you doing? It's Roland Jones. Obviously, I'm not giving legal advice. This is a CLE course, or you can watch it for non-CLE, continuing legal education credit. But it's not advice on your particular case, obviously. So I'm going to be talking about ethical issues in bankruptcy law practice, and I think the subheading for this could be, how not to get sued for malpractice and how not to get disbarred, because a large percentage of legal malpractice and disbarment proceedings involve some of these ethical issues, especially conflict of interest and some other issues. So it's worth listening carefully to try to avoid troublesome situation and some bear traps. All right, divided this course into subtopics. So the first subtopic is non 327A conflicts. So what is 327A? 327A is a section of the Bankruptcy Code where an attorney is going to apply to be approved as attorney for the debtor. So it's a section that has requirements. There's also bankruptcy rules involved with that, and it's sort of a different area than general non 327A conflicts. So I'm going to be talking about, in general, non 327A conflicts and case law relating to that. And then I am going to go into 327A conflicts and problems and specific situations that anybody applying, making a 327A application should be familiar with. We're going to spend a lot of time on this case. This is a recent Southern District case, New York Southern District. It's a recent 2017. The reason I'm spending a lot of time on this is because the judge, in the opinion, went into a lot of the issues that you, as an attorney, need to know about as far as conflicts and a lot of the principles that are involved and the relevant rules. And also, it's good law. Hasn't been reversed by a court of appeals, still applicable. And I thought it was a very helpful case. I'm going to be spending a lot of time going into the facts and how the judge applied the relevant code sections. All right, so the basic facts of the case, I'm not going to spend a lot of time on. It's not really relevant. So the plaintiff brought a housing discrimination action against an owner of co-op building, Turin Housing Development Fund. We call him Turin. He was alleging that the co-op was discriminating against Asians and involved in some kind of scheme to avoid selling apartments to Asian Americans. He also sued Douglas Elliman, who was the managing agent for Turin. So Turin and Douglas Elliman, DE, as I'm going to call them, are co-defendants, and they chose to be represented by one counsel. Eventually, that counsel was Adam Lightman Bailey, ALB. At the beginning, there was another counsel. I'm going to go into that a little bit later. So why would two defendants hire the same counsel? So the main reason is to save money. So as everybody knows, litigation can be extremely expensive. And if the interests are aligned, or they seem to be aligned, it seems like there are no potential conflicts, it makes sense to hire the same lawyer because he's basically doing very, very similar work, and especially in a situation where the facts are very similar, it's the same fact pattern, or it seems to be the same fact pattern, and the same law is going to apply. And also, you may want to collaborate as defendants and help each other or help your lawyer defend the case. So there are a lot of reasons why defendants are going to represent the same counsel. Unfortunately, it can create a lot of very serious conflict problems, and as we're going to see in this case. Yeah, so basically what happens in this case, and just to provide a quick summary, is that Turin, represented by ALB, sues Douglas Elliman in New York Supreme Court. And the basis of the lawsuit seems to sort of replicate the plaintiff allegation in the federal case. So suing Douglas Elliman for negligence, not getting the proper insurance, not managing its staff properly as an agent, and essentially they want to be compensated if there's a judgment against Turin in the federal action. So the plaintiff files a motion to disqualify ALB. ALB files an opposition on behalf of Turin. At the same time, withdraws from representing Douglas Elliman in the federal action. And the court grants the motion to withdraw as counsel. Douglas Elliman then retains its own counsel in the federal action and joins in plaintiff's motion to disqualify ALB. The plaintiff's position is that withdrawal from representing Douglas Elliman is not sufficient, that ALB should withdraw completely from the case. So, summary of the arguments: Douglas Elliman says, you got to withdraw from the case totally. You sued us in state court while you were representing us in federal court, and you can't drop us and keep the other client. You have to get out. And then ALB is arguing, well, you entered into a joint defense agreement, JDA. We informed you of this conflict or potential conflict, and in the JDA, it specifically said you waived your right to object to our continuing to represent Turin if we withdraw, or another party, or one of the parties if we withdraw from representation of the other party. The problem I'm going to go into is that the JDA was entered into between these defendants and the predecessor law firm, not ALB, and their issues with the JDA. But this brings up an important issue. There are a couple of important issues here. First of all, what can you waive? What is appropriate to waive? First of all, how do you waive a conflict? What are the rules about that? Which conflicts should be waived? Should all conflicts be waived? Some conflicts, potential conflicts, actual conflicts? And then how exactly do you waive a conflict? What do you need? What information does a client need from the attorney to be able to waive a conflict? And all those issues are covered by this case. So the first thing the court says is that resolving a disqualification motion requires a painstaking analysis of the facts of the case. And why is that? Because courts are reluctant to grant these motions. And why is that? Because it's an attempt by one side to basically screw up another side by forcing them to get rid of their counsel. I mean, really, what does the plaintiff care if there's a conflict of interest between the opposing law firm and the opposing law firm's clients? I mean, why would they care? They care because it's a good way to. I think it's a good way to create a lot of expense for the other side. They have to retain an entirely new counsel. They're going to have to put in a new retainer. That counsel is going to have to catch up. So it's a good strategic move, and for that very reason, courts are reluctant to grant it. So they grant a motion to disqualify. So it's got to be an obvious and really a good reason to disqualify counsel. All right, so the court indicates in its opinion that it's going to be very meticulous in analyzing this. It sets out what it's going to do in the opinion. It says it's going to review the terms of the JDA entered into between Turin, Douglas Elliman, and ALB's predecessor, and look at those terms very, very carefully, since ALB is basically relying on that to a large degree. And it's going to go into how ALB came to represent both Turin and Douglas Elliman, how it took over the representation from another firm, and how that's relevant. It's going to review the complaint filed in state court where Turin is suing Douglas Elliman and how that's relevant. It's going to review the procedural history of the disqualification motion, going to focus on the arguments, and it's going to address ALB's motion to withdraw. And is that good enough? Okay, so the court took a close look at the terms of the Joint Defense Agreement, the JDA. So this was drafted by Schneider Mitola. I don't know if I'm pronouncing that right. It was the predecessor law firm to ALB. And Schneider represented both Turin and Douglas Elliman. And everybody signed this JDA. So the JDA provided for sharing costs. That's the best part. But the parties may be required to share confidential information relevant to the action. Also provided that confidential information will remain privileged and protected among. This was a little bit confusing. I think the court found it confusing too. I mean, basically, each party will have attorney-client privilege with the lawyer, with the law firm, separately. Each party will have attorney-client privilege, but confidential information that is relevant to the action needs to be disclosed. That's not confidential, and the lawyer can share that information, and the lawyer is required to share that information. It said that in the JDA. And that kind of makes sense. If you're representing both parties, you want to be able to share relevant information. And if the law firm has beneficial information for one party, then it has an obligation to that party to disclose it to that party. So and I've seen that before in joint defense agreements. So it has an attorney-client privilege that's in place with each of the clients, but there are limitations to it. Also, none of the information can be shared with outsiders that are not represented by the law firm in this matter, outside of this joint defense scheme, and that without the permission of both parties, so that the information shared remains confidential. There's a lot of case law on that. There's 25 law reviews on confidential information in the context of joint defense agreement, and basically that is the law that a JDA will generally protect the confidentiality of the information vis-a-vis those not in the group. Okay, the JDA also provided for a waiver of conflicts. That's important. JDA referred to potential or actual conflicts, but didn't explain them. So it didn't go into any detail. Okay, so didn't go into any detail that Douglas Elliman might be sued, and this is why it might be sued. Didn't go into any of that. Just use the verbiage, boilerplate. There might be potential or actual conflicts, and just to let you know, but without telling you what they might be. The JDA also provided for non-waivable conflicts. So these are conflicts that under the law firm cannot waive. Direct conflicts. I'll go into what those are later in the course, and also in this opinion. So the JDA spelled out the due counsel owed equal duty of loyalty, blah, blah, blah. But the important part is it did address the issue of conflicts, but did not define or did not anticipate or really intelligibly provide information on what a conflict might be, and there was a conflict. Okay, so ALB takes over, and theoretically, and that's maybe a subject of dispute, inherits the JDA, which was not between ALB and these clients, but between the prior law firm and its clients. So ALB is arguing we took over, and we inherit that agreement, and that agreement stays fully in place. Okay, basically covered this. So at some point, Turin, who is representing, I'm laughing because it's ridiculous in my opinion, but they're currently representing Douglas Elliman, and then they're suing Douglas Elliman, and somehow that's okay according to them. They're suing them in state court on behalf of Turin, who's a co-defendant, and basically they're blaming them. And what the way I read it is that this is all your fault and you're going to have to pay for it, meaning the federal the federal lawsuit. All right, so plaintiff counsel gets wind of this that this firm is representing both Douglas Elliman and suing Douglas Elliman, and this is too good to be true, and files a disqualification motion. So the court reviews the motion of the plaintiff to disqualify, and the motion says or represents that ALB must withdraw from or be disqualified from representing both its clients, both Turin and DE. And the briefing on the opposite side is no. Why we withdrew from representing DE, so conflict's over. There's no more problem, and everyone should relax. Then DE says, well, ALB concurrently represented and concurrently represents actually, or represents in the time frame that's relevant, which is at the time of the motion to disqualify. ALB concurrently represented two adverse clients. And so that's very important. And the opinion will be going into that shortly, that the applicable time where the analysis takes place is at the time of a motion to disqualify. In other words, because ALB, we'll go into this in a little bit, but because ALB withdrew from DE, and then now at the time of the litigation on this issue is no longer representing DE, it doesn't matter. It's treated as concurrently representing simultaneously both DE and Turin, because there's a reason for that, which I'll go into in a second. Plaintiff also argued that ALB's concurrent representation, not subsequent representation, concurrent representation of Turin and DE violated multiple New York rules of professional conduct, and we're going to go into those in a second. What you have to know about that is that the rules of professional conduct are persuasive, but they're not binding on the district court and its ruling. All right, so the court breaks it down into some major issues that it's going to address. So the first issue is whether ALB's concurrent representation of Turin and DE is prima facie improper, and then it's going to decide whether that can be rebutted. But the first question is that prima facie improper? All right, so this is the applicable New York rule of professional conduct, which I'm sure everyone watching, if you're practicing in New York, you've read and memorized. Conflict of interest, current clients. So it's so important, I'm going to read it, some of it. So A, except as provided in paragraph B, a lawyer shall not represent a client if a reasonable lawyer would conclude. So there's a reasonableness. They're letting the lawyer make a reasonable decision and reason about this. So there's an option of reasonableness. A lawyer shall not represent a client if a reasonable lawyer would conclude that either one, the representation will involve the lawyer in representing differing interests. Okay, so that's a judgment call by the lawyer, by a reasonable lawyer. So it's an objective standard. Or two, there is a significant risk that the lawyer's professional judgment on behalf of a client will be adversely affected by the lawyer's own financial, business, property, or other personal interest. B, notwithstanding the existence of a current conflict of interest. So even though there is a current conflict of interest, a lawyer may still represent a client if the lawyer reasonably believes that the lawyer, again, judgment call, which personally I think is dangerous. So, okay, so I've got to make a judgment call. And what do I base that on? Nothing. I just base that on what I think is reasonable. What are you going to base that on? You could read cases, but what if you make the wrong decision? What if your decision is not reasonable? So to me, it's a dangerous provision. But anyway, lawyer can make a reasonable decision. Reasonably believes that the lawyer will be able to provide competent and diligent representation to each affected client. 2, the representation is not prohibited by law. 3, the representation does not involve the assertion of a claim by one client against another client represented by the lawyer in the same litigation or other proceeding before a tribunal. So what that means is you can't do it. Can't be waived, not waivable, just can't do it ever, no matter what you think, no matter what the clients think. Cannot be done. You cannot sue one client in the same court. You cannot represent 2 clients where one is suing the other client, basically. Can't happen, which is relevant to this case in a way. And then number 4, each affected client gives informed consent, confirmed in writing. So what does that mean? What is informed consent? How do you inform the client? And another issue is you may have an issue there with client confidentiality. You have to inform both clients. You come up in a case with a strategy that benefits one client, and now you have to tell the adverse client and get his approval, his informed consent. So you're breaching client confidentiality. This has been raised in a number of cases. It's a problem, a serious problem. But that doesn't always happen. So let's assume that's not the situation. What is informed consent? How informed does the client need to be? We'll go into that. I don't want to beat a dead horse, but that is a litigated problem, and it's an issue. Also, confirmed in writing. So confirmed in writing by the lawyer to the client, or confirmed in writing by the client to the lawyer. I would think it's a writing by the client, but why take chances? Who do both? All right. So the New York rules are based on the American Bar Association rules, which are similar, but I think somewhat narrower. And I'm not going to go into why it's not really relevant for this analyzing this opinion. So, except as provided in paragraph B, a lawyer should not represent a client if the representation involves a concurrent conflict of interest. And then it defines it. A concurrent conflict of interest exists if the representation of one client will be directly adverse to another client. New York says the same in the same tribunal. Actually, this is broader, because New York says in the same tribunal, in the same case. Or there is a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person, or by a personal interest of the lawyer. So right now we're talking about the New York rules, but the American Bar Association rules are relevant as well. And I think they're relevant just because the New York rules are basically based on those, and you don't want to violate either one. Okay, so when can you represent? Can you represent according to the ABA rules? Yes, it's the same thing, similar to New York, I think. Notwithstanding the existence of a current conflict of interest, the lawyer may represent a client if the lawyer reasonably believes. Again, it's up to you and your ability to reason. Is your belief reasonable? I don't know. I mean, I think it's a judgment call, and to me, that's dangerous. Anyway, you have a judgment call. Do you reasonably believe that you'll be able to provide competent and diligent representation? And that actually is an issue in this case, because the court, in this opinion, as I'm going to discuss, found that the lawyers were not reasonable in their belief that they could represent but that they could use this exception. It was not a reasonable belief. So what does that do? Your reasonable belief turns out to be wrong and leaves you open to malpractice. It leaves you open to a possible attack on your license. So err on the side of caution. And the representation is not prohibited by law. The representation does not involve the assertion of a claim. Again, a similar thing. You can't represent two clients in one court in one case where one is suing the other client. You would think that wouldn't need to be spelled out, but apparently it does. Each affected client gives informed consent, again, the same verbiage, confirmed in writing, whatever that means. Informed consent could mean anything. I forgot I did this slide. Yeah, so compares the two a little bit. Differing interests versus directly adverse. Um, Significant risk that a lawyer's professional judgment will be affected versus significant risk that the representation of more clients will be materially limited. I don't know. I mean, what's the difference? I mean, I think, there's a smell test, and you know it when you smell it. Current representation versus successive representation. Yeah, so just to clear something up, the New York courts, it's a little bit confusing. They um, they did have the canons of the Code of Professional Responsibility. Now they follow the New York rules of professional responsibility since 2009. So make a note of that. Okay, the case in the Second Circuit dealing with um, concurrent versus subsequent representation, and that issue analyzed in the context of conflict of interest is Cinema 5. So it's 1976 case that this case cites. I don't know why I did that slide. Canon 5 has been reconstituted. All right, there you go. Okay. All right, so the opinion goes on to talk about and make the distinction between concurrent representation conflicts and successive conflicts. And what's important about that is that there's a different standard. So a successive conflict is when you represent a new client that may have a conflict with a former client. And, the issue there is the former client may have confided certain information during the representation, and then the new, it, does it pass the smell test to be retained by a new client that's in conflict with a former client when the former client gave up information that could be used against the former client and issues like that? It's a different standard. What's important here is that the court is not applying, the court does not treat this as, in its analysis, as a successive conflict, and treats it as a concurrent representation conflict. And the reason it does that is because, again, the conflict is analyzed at the time of the motion for disqualification. All right, so why is that? Why is the analysis at that time? In other words, from the point of view ALB, we're not conflicted anymore. We withdrew. We're not representing DE anymore. We're out of that case, and it's not a concurrent conflict anymore. It's a successive conflict, maybe, because they're a former client now. No, that's not the way it works, and it's not the law. And the reason for that is the so-called hot potato rule. In other words, that would, basically, if that were the rule, that would encourage a lawyer to make a decision. Who is he going to get rid of? So there's a conflict. I'm going to drop one like a hot potato. That's why it's called the hot potato rule. So which one am I going to drop? So I'm going to drop the one that's less profitable, probably, or that's not a long-term client, or any reason I want. but one of them is going to be dropped like a hot potato. And basically, the courts say, leaves a bad smell. It's it has a bad unethical smell to it. It's kind of a betrayal. Not only was the law firm conflicted, but to add insult to injury, we're also going to drop you as a client, and we're going to represent the other client. And so, according to the hot potato rule, you shouldn't be allowed to do that, and that's why uh, con- a concurrent conflict of interest is analyzed at the time that a motion is brought, not later when the client is dumped. It's too late. It's too late to dump the client. You're going to lose both clients. If there was an impermissible conflict of interest, you represented two clients at the same time, and it was not permissible. You got to withdraw from both, or you're going to be disqualified from both. That's basically the rule. Yeah. So I already said that. Abandonment. Don't abandon me. It's a crappy feeling to be abandoned by the conflict. Your lawyer's representing someone that's suing you, and then you're abandoned. Not good. Yeah, I went into that a little bit. So successive adversary representation is a different standard. It's a lower standard, so it doesn't apply in this situation. It's important to know that it's prima facie improper. It's not representing adverse party. In other words, the burden is now on the lawyer to show why. If there's a concurrent conflict, then you've got a problem. It's on you. You've got to show why it's appropriate, why it's permissible. It's your burden of proof. Okay, so you can show, there are a number of ways that the attorney can rebut the prima facie case. But it's hard going, basically. And the cases basically say it's a heavy burden. I sort of answered that, but not really. There's another issue here, and that is it's not really, and the court had a little bit of a problem here because Turin did not represent. I'm sorry, ALB did not represent Turin and DE conflicting in the same action. That's the prohibition in the New York rules. So it wasn't the same action. It was a different action. So it's not, by definition, is this prohibited? Because strictly speaking, this is not a conflict that is unwaivable because it was a different action, and the court addresses that. And what the court basically says is that the court acknowledged that and basically said, well, it's kind of pretty much the same thing because and the court went into it in some degree. I'm not going to go into it as much as the court did, but basically the court said it's equivalent to a cross claim in the same action because Turin was essentially blaming DE for its troubles in the federal action, and it's essentially like a cross claim. And so it is, the court treated it as if it were in the same action. Also, rulings in the federal court could help Turin in the state court action. And so there were the claims were too close, and the actions too intertwined for the court to treat it as a completely separate action, essentially in an equitable sense. All right, I got ahead a little of myself in the slides. I'm going to flip through them. All right, I'm going to flip over to issue 2 raised by the court. Whether the conflict arising out of the concurrent representation of Turin and DA was cured by the JDA, the Joint Defense Agreement. So, assuming for the moment that it's not a concurrent conflict. It is a waivable, or it is a concurrent representation, but it's waivable. It's not in the same not in the same case, not in the same tribunal. So let's say it is waivable. So the issue here really is, was there informed consent? Did the joint defense agreement consist of, somehow consist of informed consent, whatever that means? Okay, so you've seen this before. So it's four. Each affected client gives conformed consent. So is this or is it not? Same thing in ABA rules. Okay, well, obviously the court found that it did not, but I'm going to go into why because it's important. I got ahead of the slides again a little bit. All right, well, this is important. It defines informed consent, requires that each affected client be aware of the relevant circumstances, including the material and reasonably foreseeable ways that a conflict could adversarially affect the interests of that client. I don't know. Was this reasonably foreseeable that at that time, or at any time, or at the time that the Joint Defense Agreement was entered into, or when ALB took over, was it reasonably foreseeable that there would be a conflict, that that Turin would sue its managing agent, DE? Is that reasonably foreseeable? I don't know. I'm not the lawyer at the time, but I would think it probably would be, especially since they ended up suing them. I would certainly, if I were Turin's lawyer, I would certainly go through the options. So anyway, so that's an issue that you have to, when you're drafting up an informed consent disclosure, are you reasonably foreseeing, are you reasonably foreseeing all the potential conflicts, and are you disclosing those? And that's informed consent. Not that easy. So I've already discussed this. Just because they have informed consent, you could give informed consent like crazy, and it doesn't matter. If your belief is not reasonable, that you should not be representing these, that you can represent these two clients. Again, it's a judgment call. So no matter how great your informed consent is, it doesn't matter. That's the other element that comes into play. And here, that came into play in this situation, and the court found that there was not a reasonable belief that representation could be undertaken. Okay, this I already showed to you. Okay, so first of all, there was the issue. Does that even Turin was the second lawyer. Turin took over for another lawyer. So it was the other lawyers at JDA with the clients. The clients entered into agreement with another lawyer, not Turin. So Turin said, "Well, it doesn't matter. That's the agreement applies." Didn't provide any argument of case law or rules or anything. And the judge basically, no, it doesn't apply. Why does it apply? Novation wouldn't apply here, and you don't have an agreement. So she threw that out basically. The other thing the court found is that even if the agreement was validly between the clients and ALB, even if there was an agreement, which there wasn't, there was no informed consent because there was no verbiage indicating foreseeable potential conflicts. It was just verbiage saying, there might be a potential conflict. Not enough. And the court found that's not informed consent. There wasn't really a separate writing either that was executed or anything like that. It was stuck into the joint defense agreement. I think that was a factor. But there's just no detail. There's nothing to inform. Essentially, there's nothing to inform DE that it's possibility it's going to get sued. Does it really want to have the same lawyer um, as Turin when there's a potential, there's a potential case against it? Um, and I think a pretty obvious potential case against it. So, there was no informed consent. So they couldn't hide behind that or use the JDA to protect themselves. So the court, in the opinion, again concludes that there was no concurrent conflict in the federal court proceeding, but when Turin sued Douglas Elliman in state court, then that's a conflict, a current adverse conflict that, because of the court's interpretation that this is essentially one case, cannot be waived. So the DE defendants, they could sign 10 joint defense agreements, it wouldn't matter. They can't consent to it. Not consentable, in the court's opinion. So the law firm argued, ALB argues that DE waived, in the JDA, DE waived continued representation by Turin and agreed that by ALB, and that ALB can continue to represent Turin. But the court basically threw that out the window, and the argument that ALB was making in another aspect of the JDA is that the JDA specifically protected ad representations with respect to confidential information, that some could be shared, some could not be shared, addressed that issue. And the court found, well, this argument with respect to confidential information is relevant to successive representation. Yes, that's the issue with successive representation, like we spoke about, but it's not relevant here. This is a concurrent, simultaneous conflict, very different, and the standard is much higher. So that this defense did not fly either. So the third and final issue: was there an actual or apparent conflict in loyalties or diminution in the vigor due to ALB's concurrent representation of Turing and DE? And that's the issue. And the court threw out the arguments on successive representation is not relevant. The court applied the Cinema 5 factors: apparent conflict of loyalties, risk of trial taint, plaintiff's motivations in making the motion to, and we already discussed that, making the motion to disqualify, and those are the factors considered. So basically the court concluded, that, there's a big stink here. And the court threw the law firm out and agreed and granted the disqualification motion because, the way the court put it, it lost confidence in ALB's ability to represent anybody faithfully in the case. I don't really see why it could still represent. I don't understand that part of the opinion, frankly, because it could still represent Turin, I think, faithfully. But I think what the court's really saying is we've got to protect the integrity of the legal system, and this puts a taint on the entire legal system and lawyers also. It's just not conduct that we can accept. Also, again, there's the hot potato rule. The court does not want to approve or condone dumping some clients that you've essentially betrayed by entering into a conflicting situation with another client, and it's just not something we want to encourage. There you go. Again, the hot potato rule. I like the way I like that phrase, hot potato. Yeah, so I'm going to wrap up this thing, analysis of this case. And again, there was a difficulty here. It's not really a direct conflict in the same court. It's not. That's the prohibition in New York rule, the ABA rule. But it was bad enough, basically. It had smell. Not to beat a dead horse, which I'm going to do. I'm going to beat it to death. or beyond death, but it's not waivable. And what's tricky here is that it's not waivable. Yes, even if there was no informed consent because the information given to the client was not sufficient, so the client theoretically was not informed. So, but even if there had been informed consent, then you're relying on the attorney's reasonable belief, and there you go, not reasonable. So is your belief reasonable? Who knows? Maybe it's not going to be reasonable. Maybe it's going to be found not to be reasonable. I just take that, in my practice as guidance to be very reasonable. There cannot be any possible doubt that my conduct is reasonable or not reasonable. I mean, do you really want to risk your license? You want to risk being sued, and just the entire unpleasantness of being disqualified? It's not worth it. All right. Next case I'm going to talk about is El Camino Resources versus Huntington National Bank. I personally found this to be a very bizarre case where a law firm somehow decides it's okay to represent both the plaintiff and the defendant at the same time in the same action. I don't understand how a law firm could think that was okay. So to me, this is a very bizarre case. It's a complicated case. In all these motion to disqualify counsel cases, the facts are very important, and typically they're fair. In this case, they're pretty complicated. I have to go into them in order for you to understand the holding in this case, but it's illustrative of a number of good principles. This is a Michigan case. However, bizarrely, the New York law comes into play because they cite some New York law and comments to that law. And anyway, the principles are the same, basically. So it's a good case to take a look at. All right, so basically this involved a gigantic fraud by an entity called Cyberco. Eventually was put into involuntary bankruptcy, but at first it was out of bankruptcy. Cyberco was involved in computer leasing and basically stole money from banks and stole money from other folks. And so this is a battle between two banks. So just to give you like a summary, my summary, you have Midwest Bank that was a secured lender to the tune of about $5 million, and then there's Huntington National Bank, which was out, I think, like $15 million, another lender. So basically, there's this huge fraud. I'm not going to go into another entity was E Plus Group. I'm not going to go into that too much, just to keep it a little bit simple. And so everybody's claiming they were defrauded. The question is, who has right to any money that's recovered? So automatically, the two banks are basically on opposite sides. And it basically just gets worse after that. So I'm going to summarize that a little bit. Obviously, I'm going to go into a lot of detail later. But basically, this is an adversary proceeding brought by a few entities, E Plus Group and Bank Midwest. The important thing is that it was brought by Bank Midwest. And it's an allegation, it's an adversary proceeding basically saying that the Huntington Bank, aided and abetted the debtor's fraud. So the action is being brought by Bank Midwest as an adversary proceeding, and Pepper Hamilton is representing Midwest. I'm going to call them Pepper going forward. Problem is, Pepper is also representing Huntington, or wants to represent Huntington. And so that's the problem. The judge in this case, it's pretty transparent in the opinion that he's completely outraged by this situation. Essentially, Pepper was representing Bank Midwest, and then it was approached by Huntington. I'll go into that in a second. And the Huntington representation was a potentially very lucrative one, and they decided, they want to represent both. I guess they tried to represent both the plaintiff and the defendant. Then they withdrew from representing Midwest, and we had the hot potato issue again, where they're dumping a client and going with I would have to assume is a more profitable client, Huntington. Eventually, they billed Huntington around 400K or 450K, so it's a substantial billing opportunity. So at some point, Midwest makes a motion to disqualify Pepper Hamilton from representing Huntington as a breach of the firm's duty of undivided loyalty, and that brings us basically to this opinion and the briefing that is involved here. So as you can tell in the slides, I'm just going to give you a general background of what happened here. So Cyberco comes to a halt. Everybody finds out it's a big fraud. Midwest, using Pepper Hamilton, gets involved in forfeiture actions that the U.S. government files against Cyberco, and then an involuntary bankruptcy is filed. Midwest again gets involved in adversary proceedings against Cyberco, and they're represented by Pepper Hamilton again. And the general effort, obviously on part of Midwest, is to get some of the funds that are recovered in the forfeiture actions, or to claim the funds in bankruptcy court, and to establish some kind of a constructive trust argument, and to litigate that. The problem is there are the banks, there are the folks that want that money, and one of those banks is Huntington. All right, so I already talked about this. That happened in, I believe, 2004. Yeah, December 9th, 2004, an involuntary is filed against them. And then they convert that into a voluntary. So Huntington was represented by another firm. Not sure why they wanted to switch to the Pepper firm, but at any rate, again, like I said before, Pepper Hamilton is representing Bank Midwest, asserting its rights in the adversary proceeding. Now, part of that, in one of the adversary proceedings that it filed, served a subpoena on Huntington, and Midwest served the subpoena on Huntington. That case was later settled between the two banks, but Pepper was representing Midwest at that time. Another case was a civil action, and I think I just bring that up in a slide so you know that Pepper Hamilton was representing them outside of bankruptcy court as well. I believe that was I'm assuming that was stayed by the bankruptcy. I think that was brought pre-bankruptcy. Just another example of Pepper Hamilton's representation. Then in 2005, Midwest includes Huntington specifically in another action, in another adversary proceeding in bankruptcy court. What's critical here is that the in-house counsel for Midwest filed an affidavit in the course of this motion to disqualify, saying that confidential, and not surprising, confidential attorney-client conversations took place, that Pepper Hamilton had access to all the relevant documents, and that these documents and conversations discussed legal claims against Huntington and Huntington's possible defenses to the legal claims. So I'm sure it's a little bit disconcerting that having all this information, Pepper Hamilton is now representing or wants to represent Huntington. Not rocket science here. Well, not surprisingly, Pepper Hamilton is poo-pooing these concerns and basically saying, well, we didn't do a detailed fact review and we didn't have any knowledge that Midwest was going to file this instant adversary proceeding, or that Huntington was going to get sued, and there was no direction to develop a lawsuit. And but Pepper acknowledged that the subpoena raised a conflict of interest question, and decided, in the slide it says to ignore. I'm quoting the court there. That's actually a quote, not my language. So the court says, in the opinion, decided to ignore after due consideration. So you could sort of pretty obviously tell that the court is irritated and leaning towards its decision, giving you little tidbits. All right. Well, what started this whole problem really was the trustee adversary proceedings trying to avoid payments to Huntington. So they're basic clawbacks, preferential payments, fraudulent transfer payments. And the trustee sued a lot of folks. Huntington was one of the defendants. And for whatever reason, Huntington at first used its own law firm, but Huntington decided it wanted to retain Midwest in defending these actions. So that's really what started this whole issue. So it started to see a flurry of activity. Huntington tries to retain Pepper Hamilton in the adversary proceedings, and then Pepper Hamilton goes back to Midwest with a proposed conflict waiver agreement, drafts a couple of them, and we'll see what happens with those. So the first thing that happens is Pepper Hamilton goes to Huntington and say, there's a potential conflict here. We represented Bank Midwest. I'm sure Huntington already knew that, in the forfeiture action, some other actions. And Huntington says, fine, we have no problem with that. And then, I have some theories why they were okay with that. But anyway, they're fine with that. Great. And then, so Pepper Hamilton goes to Bank Midwest with a proposed conflict waiver agreement that's extremely broad, and asked Midwest to sign off on that. So basically, from reading the opinion, it looks like Pepper Hamilton went to Bank Midwest and said, we want to represent Huntington in defending these adversary proceedings. It's a very, very limited thing. But at first, they go to Bank Midwest with a very broad waiver letter, and Bank Midwest specifically declines to do that. Also, in the agreement, there's no acknowledgement that Pepper Hamilton is going to represent Huntington in a potential adversary proceeding that may be brought by creditors. And there's no anticipation. In other words, there's no anticipation of any other action, any other potential conflicts between Midwest and Huntington. Midwest granted a very, very limited conflict waiver letter. So the letter only mentioned, the first letter, actually there were a couple of drafts. The first draft was limited, and the second draft was even more limited, that Midwest eventually agreed to. Only mentioned, for some reason, one out of the 9 forfeiture actions where Pepper Hamilton was currently still representing Huntington, and only mentioned the two bankruptcy adversary proceedings, which were closed, and of course referred to the current adversary proceedings that Pepper Hamilton was going to represent, that was proposing to represent Huntington on the clawbacks. The judge basically included in the judge's opinion, and this is the judge's language, that the only reasonable interpretation of the waiver letter in its final form was that it's limited to the Huntington matters. That seemed to be the intention of Midwest and the representation of, well, whether it's the representation of Pepper Hamilton is another issue, but that does seem to be the understanding of what Midwest was agreeing to in its signing off on this conflict waiver agreement. Yeah, what the court found to be important is that Pepper Hamilton got the conflict waiver agreement, but did not go into in writing the anticipated claim, which the judge believes Pepper Hamilton was aware might be filed or could be filed or would be filed by Midwest against Huntington. And that's exactly obviously what happened in this instant action. So sometime after April, after getting the consent, Pepper Hamilton went on to put in an answer and defended Huntington in the clawback actions. And then June 22nd, 2007, Midwest files the instant action against Huntington, alleging that Huntington aided and abetted debtors' fraud. So this is where everything explodes, and I don't know what's going to happen here, because Pepper Hamilton is representing Huntington, representing Midwest. Midwest is suing Huntington, so they're representing the plaintiff and the defendant in the same action. You would think that might be a conflict. So instead of withdrawing from one of these clients, and I would think they'd want to withdraw from Midwest, they sought a supplemental waiver from Midwest. I have to think that Pepper Hamilton must have had two sets of lawyers and maybe a Chinese wall kind of argument where they were separating the lawyers and the information. Maybe a new set of lawyers representing Huntington. I mean, that would make sense, but that wasn't really referred to in the opinion as a defense. So maybe that happened. It just wasn't referred to in the opinion. Anyway, Pepper Hamilton is representing both parties now, so it went back to Midwest and tried to get a better, a more encompassing conflict waiver agreement. So Midwest refuses, and then Pepper withdraws from Midwest, or tries to withdraw. Makes a motion. Let's put it that way. Makes a motion to withdraw. So this slide gives you a little bit of a time frame. So you have the exact same situation that was discussed in the former case. You have a hot potato situation. So we're going to withdraw from one client, and we're going to keep the new client, and all the problems that arise from that. So Pepper communicates with Midwest, saying we're done, and also it refers to the conflict waiver agreement that Midwest had signed, and said, Pepper says, well, we don't really need a change. That was broad enough anyway, and so we're going to continue to represent Huntington. And then, of course, Midwest files the motion. So this slide gives you a little bit of a, again, time frame for what happened. So we get into the substantive part of the opinion where it goes into the applicable law. So the first issue is Pepper Hamilton's representation of Huntington National Bank in the present case a clear
breach of its ethical duties, and I would say both to Huntington and Midwest. So the court goes into this issue of the problem with motions to disqualify an attorney. And you have to do it. Basically, the court is saying you got to do it to preserve the respectability of the profession. We can't have folks representing both sides at the same time. Also, the court goes into this issue that it's an extreme sanction, and there's got to be a specifically identifiable impropriety. It's got to be pretty obvious, because you're denying the ability, in this case, of two parties from retaining the lawyer that they want to retain. Actually, in this case, it's really just Huntington. That's not because I think the relationship between Midwest and Pepper is basically over. But Huntington is not going to be able to retain if the judge grants this motion. And it's a huge hassle and huge cost to retain a brand new counsel. New counsel is going to have to be educated. So again, it's the same kind of thing. We don't want to encourage folks from using this, from gaming the system by trying to get rid of your opponent's counsel and costing your opponent a bunch of money. This is an issue also that's important. So the ethical rules are not binding. They're basically guidance that the court's going to look to. And also, the fact that an ethical rule was violated does not mean that the court has to disqualify counsel. So it's citing the relevant conflict of interest rule. A lawyer should not represent a client. Representation should be directly adverse to another client, unless each client consults after consultation. So that's the Michigan rule, a little bit different from the New York rule. They're analogous, but they're a little bit different from the New York rules and the ABA rules, as we've seen. This is a New York rule. A little bit different. We already went over that. Especially, what's relevant here is especially B, notwithstanding the existence of a concurrent conflict of interest with this, which this obviously is. B4, each affected client gives informed consent confirmed in writing. So did that happen here? Was there informed consent or not? So the first issue the court deals with is this concurrent representation? Because Pepper had terminated Bank Midwest. The motion to withdraw was not granted, but it had terminated the representation. And so, cured. There's no longer any conflict here. We can represent Huntington. So the judge is basically, no, that's not the case. It was concurrent representation, and it is concurrent representation because that's determined at the time of a motion to disqualify. Okay, so the next few slides I basically talk about that. Again, you can't cure, if you have a direct conflict between two clients, you can't cure it by firing one of the clients. It just doesn't work. And also, I think the basic thing is that it's offensive to the client that you're dumping for the other client for obvious reasons. And it doesn't help the reputation of lawyers. There you go. Dramatic form of disloyalty. You're not only abandoning your client, but you're taking the other side. There you go. Insult to injury. Right. So I don't know if it is. The rule is not triggered by greed. I don't know if dumping one client and getting a maybe a better paying client, whether that's greed or not, I don't know. Whether that's a great motive, I don't know. But it's not the issue. It's just that you have a duty of loyalty, and it casts a bad taint on the profession to dump one of your clients in in these circumstances. There you go. The reason I have this slide is when Pepper is attempting to dump Midwest and keep Huntington, the argument there is it's not a concurrent conflict anymore. It's a former client, and so it's not concurrent, and so a different standard applies as to whether Pepper can continue to work with Huntington. So it's a whole different standard, and that argument's going to be rejected. So the court makes its its conclusory statement. There's no question that the interests of plaintiffs, on the other hand, and Huntington National Bank, on interests of plaintiff on the one hand, and Huntington National Bank on the other hand, they're adverse. The hot potato rule. Clients are not hot potatoes. Can't be treated like that. There we go again. So maybe I'm beating a dead horse here, but this is a quote from a case that the opinion cites. Like I said, I don't want to beat a dead horse here, but you know, it kind of makes sense as an argument for Pepper Hamilton. We are curing the conflict. No more conflict. So you would think you would be able to do that because you are curing the conflict. But the hot potato rule prevents that. And why does it prevent that? I think it does cure the conflict, and maybe the former client standard should apply, but basically the courts are saying they're just not going to tolerate the smell. That's what I think. Yeah, so I'm not going to go into the rules that apply to former clients and then representing new clients that maybe were in conflict with the former client, and that involves really, did you have confidential information from the former client that you're going to use with the new client? Was there a substantial for the new client, and was there a substantial relationship between the present matter and the former one? So it's a whole different analysis, basically, about confidential information. All right, so slide I already covered. So the point I think the judge is making is that everything was fine until this direct lawsuit. That's what caused the problem. So I'm sorry, not Midwest. Pepper Hamilton's main argument is that we got a waiver. They signed a waiver. So we complied with the rules. And Midwest, we got Midwest's content. It was brought, and we can continue to represent them. The court basically, and the argument was that in the waiver letter, the language, and this is the language, we further confirm the Midwest consent if given would not be deemed to be a consent to our representation of Huntington as a party in any other litigation in which Midwest may be or become adverse. So Pepper Hamilton was arguing that other litigation was not any other litigation relating to the Cyberco case. In other words, this case, other litigation involved other litigation having nothing to do with this case or this bankruptcy. And it was not a very strong argument. And the judge basically shot it down and basically said that, that's ridiculous. And if they meant that, then they should have said that and be very specific about that. That any other litigation involving, in this case, in Cyberco, is not covered or is covered by the waiver agreement. But that wasn't done. And just the judge did not spend a lot of time on that argument. So the other litigation argument, like I said in the last slide, meh. Yeah. So the other argument, I'm laughing because it's the opposite of what the case law is. So Pepper Hamilton is arguing that it's the client's fault. They didn't, Midwest didn't tell us. It's their burden to disclose this intent to sue Huntington. If they told us, then we wouldn't have represented both parties. They didn't disclose it, and so the waiver letter applies. We would have addressed that in the waiver letter, maybe. So they didn't explain it correctly to us, and therefore they waived it. So the judge said this stands the law on its head, which it does. It's the law firm that has the burden of anticipating conflicts and describing them to the client so the client can decide whether to waive these potential conflicts or not. I mean, who wants to do that? If you want to keep the client, you're certainly not going to want to describe every possible conflict that's going to come up, in the future, because you want to keep the client. But you have a duty to do that. You have a duty to tell the client, like, this might happen, that might happen, and address it. Here, it wasn't addressed in writing. It wasn't addressed in the waiver agreement. It's just not what the law is, not what the law requires. So to be sufficient, the disclosure of risks or potential conflicts and issues that are going to arise in the future must be in such detail that the person can understand the reasons why it may be desirable to withhold consent and get another counsel. So it's the burden is on the lawyer, not the client. All right, so this is the judge's opinion. Utterly insufficient. Disclosures were no good, and so the waiver agreement doesn't protect Pepper. Yeah, the other thing is cases discuss, and other commentators discuss, it's not just sending a letter or boilerplate or something like that. You really have an obligation to speak with the client on the phone or nowadays on Zoom, and really make sure the client understands. So it's not just covering your butt. The client really has to understand what the potential conflicts are, to the extent that you can anticipate them. So the judge looked at the record, and that just didn't happen here. Or if it did happen, then it's not on the record, and there's no evidence that it did happen. Well, this is the court's conclusion, and it didn't help that there were a couple of drafts of the waiver agreement, and the first draft was rejected. There was testimony that, hey, that's too broad. We're not going to agree to it. And then a second draft that Midwest looks like they reluctantly agreed to it, and it looks like the representation was, at least reading this opinion, that we're gonna, Huntington has been sued for a couple of clawbacks, and the representation is limited to that, and that's it. Now, here the judge goes to the smell issue, and that it basically Pepper dumped Midwest because it was more profitable to represent Huntington. Was offended by that. I mean, the revenues here are fairly big numbers, 400K, 500K, and that's just what came out in the opinion. It may have been a lot more than that. And judges make what, 150K? All right, so the court raises the issue of, yes, this is a violation of the ethical rules. But that's not enough. We also have to find specifically identifiable impropriety, blah, 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 and we do. So, you got to be like the emperor's wife, beyond reproach. Given the reputation of lawyers in this country, which is below used car salesmen, um, there's no mystery why the courts have to do their best to preserve the integrity of the bar. So Pepper argues that the thrust upon defense, which is a line of cases, should apply here. And what that means basically is, hey, it's not our fault. There was a merger, something happened. We ended up representing conflicting parties. So not our fault. It was thrust upon us. So the lead case here is Gould, which is often cited. In that case, Jones Day was representing Gould, suing Pechney, however you pronounce that, Pechney. And then Pechney bought IGT. Jones Day had representing IGT, so now Jones Day is representing both Pechney and Gould and suing itself, representing two clients that are suing each other. And so Jones Day refused their request that they withdraw as counsel, and the way it played out was that the judge found that there was a conflict of interest and a violation of the ethical rules by Jones Day, but that Jones Day could withdraw as counsel, could decide which client it wanted to withdraw from, and could withdraw. So essentially, the hot potato rule doesn't apply if it was thrust upon you. This slide continues, a little ahead of myself, what I just said. So the Gould factors, what are those? However you pronounce that, Gould. No prejudice of the present client from representation of a new client. No exchange of confidential information. Delay in the process of the case if you have to withdraw from both cases. Conflict was created subsequently after commencement of the case of the new client. So in support of its position, Pepper cites an opinion issued under New York Disciplinary Rule 5105A, goes into the thrust upon factors, and you could read them on the slide, a little slightly different. Okay, what's important is that the opinion stressed that the conflict has to be, truly unforeseeable and truly not the fault of the lawyer for the thrust upon principle to be applied. So the judge applied this and found this was totally predictable. Obviously, they were in conflict. The two banks were in conflict during the case. Midwest had served the subpoena. They were fighting. They were settling. And the possibility of Midwest suing Huntington on other grounds was foreseeable. So no thrust upon defense here. Very likely. Creditor claims would be very likely. And then the court addressed another argument by Pepper that, it's not our fault. Midwest sued Huntington, so it's their fault. They created the conflict. And so the judge knocks that out. It basically says if we're going to allow a law firm to blame the plaintiff client and we'd always have to allow a law firm to keep the defendant client and dump the plaintiff client if we're going to cast blame like that. So that's not going to work. So finally, the court concludes that not allowing Huntington to continue, either party, Midwest or Huntington, to continue with Pepper Hamilton is outweighed by the hassle of making Huntington dump Pepper. Basically, is outweighed by the ethical violation. And then court says it's not my fault. It's not Huntington's fault. It's not Midwest's fault. It's the firm's fault. It's their fault. So that's the judge's conclusion. Um, takeaway, I think, is why would you spend so much money and time litigating a motion to disqualify when the facts are just so bad? I don't really understand why they just didn't withdraw from Huntington. I really don't. I mean, they did bill, according to the opinion, they billed around 400K. I don't know how they billed 400K because they only represented Huntington, I think, like 3 months or something like that. So anyway, maybe it was all worth it. Okay, this is another conflict case. This time in Eastern District of New York, District Court. Fairly recent in the scale of things, 2010. So this is a case with a less complicated fact pattern. So should be a little bit quicker, a little bit easier to discuss, but interesting issues. So the plaintiff is Karen Filippi. She's suing a school board and basically saying that she was harassed because of her gender. It's a federal action. So she's represented by a relatively small firm, Stephen A. Morelli, and his of-counsel Eric Tilton. This is the problem. An associate at the Morelli firm, Lorraine Ferrigno, was also vice president of the board. So she worked at the board. She was vice president of the board. And then in the opinion, basically it says that she got to know Steve Morelli. She was working part-time. Then she came on as an associate. And she asked the board, this is before the complaint was filed, but after the board received communication from the plaintiff intending that they were giving notice that she was going to file a complaint. So they knew this was going on. So Ferrigno was an officer at the board when this all started, and then she started working for the Morelli firm full time. But she didn't resign from the board. She's still vice president of the board while she's working for the Morelli firm, while this is going on. However, and I'll go into the facts later, in a couple of seconds, she did get the board's verbal consent. Is it okay if I work for the Morelli firm? Yeah, fine, go ahead, not a problem. We'll see how well that worked. Right, so this slide is a little bit ahead of me, but basically, she spoke with the board, and the board said, yeah, that's fine, as long as she doesn't have access to the Filippi file. So she doesn't have access to the file, she doesn't work on the case, she has nothing to do with the case, fine. Then the board gets sued, and the board changes its mind, says, this is not right, and we're going to move for the disqualification of the Morelli firm as counsel for the plaintiff because of a conflict of interest. The board contended there was substantial inescapable conflict of interest under the New York State Rules of Professional Conduct, and the law firm argued that there's no conflict. Ferrigno was not an attorney and is not an attorney, although it's still vice president. It's not an attorney. There's no attorney-client conflict here. And also, I had nothing to do with the case. I didn't work on this. I didn't have access to the file. And someone else worked on it at the Morelli firm. I had other responsibilities there as agreed. So there's not a problem. Plus, the board said I could join the Morelli firm, and now they're being unreasonable. The board argued, we didn't really give valid, informed consent as required in writing, as required by the rules. So did the Morelli firm have a conflict of interest with this fact pattern? Should they be disqualified? Okay, we've already seen the rules a couple of times now. So, the first issue is, so she's not an attorney, but for purposes of triggering an inquiry, it's enough that uh, that she's working at the board. It's not, it has aspects of an attorney-client relationship. So that's an important thing to take away. You don't have, she's not an attorney, but it doesn't matter. She's in a position, a fiduciary position. She's an officer there. And so it's not an attorney-client conflict, but it is a conflict where the court could disqualify the firm. Again, doesn't have to be an express attorney-client relationship. Can be another kind of relationship that's somewhat similar, that requires confidentiality or that entails confidentiality. So the court found that Ferrigno did have access to confidential information. In this case, the demand letter came when she was an officer there. The court presumes that there were conversations with respect to this. How are we going to handle it? What are we going to do? What's the strategy? And all that kind of stuff, which is confidential information with respect to Felipe's claim. Yeah, so in this case, what's interesting is that the court didn't apply the concurrent standard. It applied the subsequent lawyer, so it's subsequent representation standard. So it's applying basically a lower standard, and the question there is, was there a substantial relationship between the issues of the former client and the current client, in this case not the former client, but the former or the current actual relationship, but they're applying a lower standard. Basically, they're looking at confidential information. So that's the focus. So there was a substantial relationship. The issues were the same or very similar. How are we going to handle this lawsuit? And then when she joins the firm, the issue for the firm, not for her specifically, are the same. Very very identical issues as far as this Filippo lawsuit. So the next issue is not whether, this is I think critical, not whether Ferrigno had actual confidential information, but whether she had access to confidential information. Could she have known confidential information, discussions regarding the lawsuit and that kind of thing relating to this case? So it's a smell test, not an actual test. So even if she didn't have actual confidential information, it looks bad. There's a smell factor involved here. It looks bad for lawyers. So that's the issue. Defines confidential information, protected by the attorney-client privilege, likely to be embarrassing or detrimental, information that the client requested to be kept confidential. I think in this case, there's no doubt that there's possibility of access to confidential information. There was confidential information. They talked about the case. Whether Ferrigno knew about that, whether she was part of those conversations, is not relevant. She probably would have access. Doesn't have to decide, doesn't have to make that decision as far as whether she acquired the confidential information or not. She had access to it. And so, it looks bad. Not that actual damage was done. The damage is that it looks bad. It looks bad for the profession. Okay, so Ferrigno's defense is, hey, I had nothing to do with this. I didn't know anything. I didn't have the file. So how is it possible that the firm should be disqualified? And then the court goes into the presumption that client confidences are communicated among attorneys within the firm. There's a presumption that the whole firm is conflicted. They all went out to lunch together, and this came out, or by the water cooler, and there's a presumption everybody knows everything. So the court goes on to say that if there is a conflict, concurrent conflict, and the court, it's a little bit confusing because the court is now treating it as if it is a concurrent conflict. So which standard, it's not, I think the opinion is a little bit unclear there. But the burden is on the attorneys. Got to show that there is no actual or there's no apparent conflict, and vigorous representation is not diminished. So here's where the court says there is a conflict and it's not waivable because it involves an assertion of a claim by one client against another client represented by the same lawyer in the same litigation. So you can't waive that. And also, even if you could waive it, there was no waiver. There was no acceptable waiver. So one of the issues that the court goes into is the board is saying, or rather the law firm is saying, well, we discussed it with them. They said it was okay. So what's the problem? And then the court goes into an important issue. So were they informed of all the implications of this representation? That now Ferrigno is working with the firm and what could happen, what are the implications of that? What's the worst case scenario? What could happen in the future? Was that all explained? Was that all explained in writing? Was it explained on the phone? Did they acknowledge in writing that they understand, that they're fully informed? No, none of that happened. So it was all verbal and it was informal, and according to the opinion, it wasn't an informed decision, and the law firm did not educate the client properly. It's the burden of the law firm. Got to educate the client. Can't blame the client. You got to educate the client on this decision. And also, they revoked consent. So the opinion also states that the client can revoke consent, even if they gave consent. But we don't give consent anymore, so we revoke it. There we go. Appearance of impropriety. That's really the most important thing in these kind of cases. We don't want the smell. Then, the law firm goes into its defense, says, well, she didn't know anything. There was a Chinese wall. She didn't have access to the files. And we erected the wall, and we didn't discuss it with her, blah, blah, blah. So the court basically said, that doesn't really work in a small firm. It may work in a large firm. The court doesn't really say why, but I guess you can figure it out. In a very large firm, it could be, maybe you're on a different floor, maybe you're in a different building, maybe you're in a different practice group, maybe you don't even know each other. Could be a whole different situation where it's much easier to have a Chinese wall. There are a group of lawyers that are separate from each other physically, and maybe they don't even have access to the same database. Who knows? I don't work for a big firm. I don't know how big firms work, but this is, in my opinion, a little bit discriminatory against smaller firms, but there's a line of cases that agrees with this. So if you're a small firm, they assume that the assumption is, obviously, that you cannot maintain an effective Chinese wall. If there are 6 people in the firm, everybody's going to know what's going on. You're going to talk about it. Like I said before, maybe you go out lunch. It's not. I wouldn't be surprised if the whole firm goes out to lunch together and start talking shop. So it's not unreasonable. All right. So what I just said, the slide covers that a little bit. All right, so you can guess the judge's decision. I think the takeaway here is, the fact that you weren't an attorney, in a prior relationship. Doesn't matter if you had access to confidential information. The fact that you tried to create a Chinese wall for a small firm, that's not going to work. Um, and also, just the general, I mean, you could look at a situation, and also the verbal waiver doesn't work. But just generally, I mean, if there's a smell, there's a smell, and I think it was pretty obvious that there was a situation here. I mean, she was currently an officer with the entity, and the law, and she was an associate with the law firm, and the law firm was suing the same entity in which she's a vice president. I mean, there's a smell. It's not worth it. All right, I'm going to move on to a different section now of the video, which is 327A conflicts. In other words, conflicts that are present during the application process for a professional bankruptcy case. So the case I'm going to talk about is Leslie Fay. Um, it's a much cited decision and it's a Court of Appeals case, 1994, and it goes into some of the relevant issues. So Leslie Fay, it was disclosed by the controller that in 1993 that he was making unsupported entries in the general ledger. So all the reporting was bad and had enormous implications for Leslie Fay. They had to file for bankruptcy, and the numbers were all made up, essentially. So there was a bankruptcy filing. The board of directors directed its audit committee, created an audit committee to investigate the irregularities. The audit committee employed Weil, Gotchel, and Manges. I'm just going to call them Weil. So Weil is a very famous firm. I think they're probably, if not the biggest corporate bankruptcy law firm in the country, maybe close to it. So they've been around, and it's a big firm. Very, very sophisticated, high quality firm. And so they're the target here. So in April 93, Weil's role expanded as the company filed for bankruptcy. They filed the bankruptcy on behalf of Leslie Fay and applied for retention as Leslie Fay's counsel. So it had represented the audit committee that was investigating the irregularities, the audit committee appointed by the board of directors. So it was representing the audit committee, and then filed the bankruptcy on behalf and applied to represent the debtor, Leslie Fay. The court approved the retention and directed Weil to just continue its work for the audit committee. So in November 93, creditors committee and the trustee objected to Weil's application, alleging that Weil was not disinterested, as that's referred to in the applicable code section I'll go into in a second, and it didn't disclose relationships that would indicate disinterestedness. The court appointed an examiner. Now the debtor's got to spend money and waste assets investigating Weil's disclosures and disinterestedness. One thing to keep in mind is that actually, the slide says the trustee, it's actually the U.S. trustee. There was no trustee appointed. It's the United States trustee that is tasked with being a watchdog in these kind of situations, especially applications for professionals that are seeking to be employed by the debtor. So, that's one of their main jobs, is to track that and make sure that things are being disclosed properly. So here they found there were problems, so it objected. The examiner found that class actions and derivative suits had been filed against Leslie Fay's directors, including members of the audit committee, on grounds that they should have known about the irregularities, Leslie Fay's ledgers, blah, blah, blah. Weil represented some of the audit committee members in these actions. So while not only represented some of these defendants, it also had other relationships. So it represented an officer of Bear Stearns. But while Gottschall, of course, it's a gigantic firm, also had a prior relationship with Bear Stearns. Bear Stearns was the client. And also, unfortunately, Bear Stearns or this officer was a potential litigation defendant in some kind of litigation, some kind of adversary proceeding brought by Leslie Fay. The same applied to Friedman of Odyssey Partners. Again, a client of Weil, another potential target of the debtor. Also, Weil had represented BDO Seidman, another potential litigation target of the debtor. Also, Weil represented the seventh largest creditor and didn't disclose any of these things. Didn't disclose these relationships that are, possibly significant because these folks are potential targets of the debtor. So Weil has a prior relationship with them, and certainly a reason to be reluctant to sue them on behalf of anybody. So the basic issue was whether Weil was disinterested at the time of its retention by Leslie Fay. But more than that, did it follow the rules? Did it make the right disclosures? Did it act properly in its application? So 327A, except as otherwise provided in the section, blah, blah, blah. The court may employ one or more attorneys that do not hold or represent an adverse interest to the estate and that are disinterested persons. So is that definition somehow different from holding an adverse interest? I'm not going to go into that on this video, but there's been disagreement, case law disagreement on that point. But the fact is, you have to be disinterested, whatever that means. And the main point of this is that you don't get to decide if you're disinterested. That's the point of this case that we're discussing. You don't get to make that decision. You have to make disclosures, and the court makes that decision. I think this is a lot like the non-bankruptcy disclosure or waiver agreement that you have to enter into with the client when there's a conflict or a potential conflict. You're letting the client make the decision, giving him all the information he needs. I mean, it's extremely similar to that doctrine. Here, the client is the bankruptcy judge. The client is the debtor, and essentially the bankruptcy judge. 327, attorney must be disinterested. According to the examiners, there could be a perception that Weil would be unable to act solely in the debtor's best interest. So that was the examiner's conclusion. So maybe a problem here. Courts, like I said before, don't define adverse interests. Conflicts that are hypothetical or theoretical, not a basis for disqualification, but who makes that decision? Not the law firm. So that's more of a problem, obviously, but again, it's not the law firm's call on that. All right, so this is a big controversy in 327A. Are potential conflicts the problem or only actual conflicts? If it's a potential conflict that could happen sometime in the future, it's not happening now, is that any reason to deny a motion to be employed under 327A? So there's been a lot of ink spilled on that issue. So this court addresses that. So the court noted that all those cases, they basically just do a fact analysis, and they're just driven by the facts of whether this law firm should be approved or not, and it's a judgment call on each particular set of facts, and it's really a non-issue. There's no need for any distinction between potential and actual. Court found it's more productive to ask whether the professional has either a meaningful incentive to whether there's a meaningful incentive to act contrary to the best interests of the estate. So is there an incentive to do that, or is there a perception of one, which is equally bad? The court quoted another case for that proposition, in re Martin. This, I think, is also an extremely helpful standard, which anyone can use. And that is it plausible that the representation of another interest may cause the debtor's attorney, or in non-debtor situations as well, is that representation, is that going to cause the attorney to act any differently than they would without that other representation? It's a very simple question. Are you going to be acting differently? Are you going to be doing anything differently if that other representation did not exist? I think that's a very, very simple question to ask yourself. Okay, Rule 2014 is very important. And it says that if you're seeking employment under 327A, you have to submit a verified statement setting forth the person's connections to the debtor, to creditors, anybody. You have to set, and this is basically your disclosure. What are your potential? What party? What relationships with other parties might cause you to be conflicted or to act differently? And it's not your call. You've got to disclose them. So that's what this case is about. You have to disclose them. Do you have to disclose every possible relationship? There is a judgment call involved. You're not going to list everybody that you ever knew, every client that you ever had. There is somewhat of a judgment call here, but you have to set out the obvious ones. There you go. So the U.S. trustee, the court has an opportunity to decide. It's their decision. If you don't disclose it, that's a problem. When the court's deciding, should we sanction you or not? And put another way, when you do disclose, you have more of a safe harbor if it's later determined that there was a conflict and you shouldn't have been retained. But I disclosed it. You could disclose it. If you don't disclose it, looks like you knew about it and chose not to disclose it for obvious reasons. Yeah, so the main problem here is that, like I said before, the bankruptcy estate might have had claims against senior management or the board of directors, against folks that Weil Gotshal had a relationship with. So the court should have been told that, those names should have been released, according to this opinion. According to this judge, those names should have been released. It's not the call of Weil Gotshal to make a decision about that. So that's the complaint. You didn't tell me, so how could I decide? And there are potential clients here that could have been targets. Obviously, you're not going to sue your clients that are substantial clients, or maybe you'll sue them, but you'll reluctantly sue them. You're conflicted. Okay, so Weil is saying that there were no claims, there were no new claims. There was only, again, potential argument that this may be sometime in the future, but not now. So we didn't need to disclose those names. And the court knocked that down, saying, the court's saying it's my call. Maybe they were maybe they would have been liable. Maybe they wouldn't have been liable. Maybe the lawsuits would have worked. Maybe they would have been a waste of time. But it's not the call of the law firm. That's what the judge is saying. Obviously, incentive to discount any possibly, hey, the lawsuit's not going to work. Of course, you're going to want to say that if it's a current client and a substantial client. So the conclusion by the court is that they're not disinterested. And the court couldn't make that determination, didn't have the information. It's important to realize the context here. Weil Gotshal is, probably the most respected corporate bankruptcy law firm in the country. I mean, there's another law firm that could make that argument, but that's not that it's number one. But it's a very famous firm, always in bankruptcy court, always on the biggest cases. And this is the Southern District of New York, and this is the Court of Appeals. So everybody here is very, very sophisticated. So, my reading this, it's a little bit surprising to me that they didn't disclose these folks. And I have to think that, and you'll see later in the opinion why that was, but I think Weil made a decision that just wasn't necessary. All right, so now the judge is angry. We have to hire an examiner. We've got to pay for that. And we may have wanted to sue Seidman. And there's an angry judge here. There's a smell. That's what the judge is saying. There's a smell. Doesn't seem right. You got to list the conflicts. That's how the judge is going to know. Well, there you go. There's the judgment call. All connections, but not de minimis connections. So it is a judgment call, but you probably want to err on the side of disclosing even connections that seem somewhat de minimis. All right, so the court sanctioned Weil Gotshal. I'm sure Weil is very seldom sanctioned, but they had to pay the cost of the examiner's investigation into these conflicts. What's interesting is that the court found that the examination showed that there was no cause of action against these people, and therefore, it was all basically Weil's judgment was correct in the end, and there was no cause of action, and Weil can remain as counsel. And why? Because they're one of the best firms around, so we don't want to kick them out. We need them, so they're going to remain as counsel, and since there are no conflicts. And Weil's judgment in the end was correct. So what wasn't correct is that the judge should have made that call and had an opportunity, and there was a big to-do, basically over process, and the right process wasn't followed, and the judge, I guess, decided to make Weil an example of that, or didn't have a choice. So the end result is court found that Weil was not disinterested, had failed to file a complete disclosure. Court limited sanctions to the disgorgement of Leslie's Fay's costs in investigating, which is, for a firm that size, is a rap on the knuckles, but don't want to be sanctioned. So it was permitted to complete the work, and everybody went on their merry way. All right, this is another 327A non-disclose issue and conflict issue. So it's 1994 Southern District of New York bankruptcy court level. So this involves the firm of Wendell's Marks, also a very, very well-known firm, very well respected. They sought So this started when they sought payment of fees and reimbursement of expenses for handling the debtor representation of Source Enterprises, which was a media company. Wendell had also represented an equity holder and was a creditor of Source prior to its application for retention. It didn't disclose that properly. It told the U.S. trustee, and I think we'll go into it later in the slides. Basically, told the U.S. trustee that it was writing off the debt, so it would not be a creditor of the debtor. So that's important. Wendell's withdrew from representing as counsel for Source for non-payment, and then filed the proof of claim in a rather large number, 548 and change. So on March 28th, 2007, Wendell's filed its first fee application, and that's when stuff hit the fan. So the trustee's office and other creditors filed objections to the fee application and alleged that the law firm was not disinterested and held an interest adverse to the estate at the time of the approval of its retention, and didn't disclose these things. So was it disinterested? Did it violate the disclosure requirements just because it was owed money that it later tried to collect? So the applicable code section is 327. Applicable rule section is 2014. Not going to read it. You can read it yourself. Interest adverse to the estate is defined by a court as as Leslie Fay defined. A lot of courts quote Leslie Fay on that. Would you have acted differently? I think that's a great definition. That's it. In 2014 is very important. That's essentially the teeth behind 327, 327A. That's how the court's going to tell. And it's the court's decision. Basically, you have to disclose. I mean, I'm not going to beat a dead horse. We already discussed this in the last case. So let's go into the facts a little bit here. So Wendell's was owed a considerable amount of money pre-petition by the debtor before filing the petition, and also requested that an equity holder, BEGS, pay the invoice. Told the U.S. trustee it was writing it off. Apparently, it wasn't writing it off. BEGS did pay some of the invoice, and the rest would remain unpaid. So the problem with that is that it has an entity, BEGS, that holds equity, and it's seeking to get paid, and so it's conflicted. It can be influenced by BEGS, unconsciously, consciously, whatever. BEGS is going to pay at some point, maybe. Well, the court was not enthusiastic about paying Wendell's, and basically made a statement, rather harsh statement, that they were chasing to get paid, and that was their main focus, not helping the debtor. So in making this decision, the court cited evidence I'm not going to go into that Wendell's was favoring BEGS, an equity holder, over unsecured creditors, possibly to obtain a later payment. The implication is that BEGS was holding their feet to the fire and wielding influence and clouding their judgment. So the court concluded that that actually the slide says source, but I think I meant the law firm was breaching its fiduciary duties, so you can disregard that because of control exercised by BEGS. And this arrangement, it was just, if it wasn't a conflict and BEGS was not influencing Wendell's, it was the appearance of a conflict. It was something just as bad. So that's the conclusion. So it denied its fees, all of its fees, and had to disgorge its the previous payment of fees to it. A very harsh punishment, um, and even denied reimbursement of expenses. I guess it was forcing Windows to reapply for those, but you can imagine that I don't think the court was in a very generous mood when they reapplied. So the lesson is, I mean, I think it's a harsh opinion. The court was obviously irritated, and the lesson is to disclose all possible conflicts, and otherwise you're going to pay a big price.